This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Anti-Federalist Papers, Section 32, Brutus Letter 12. Read by M.L. Cohen, Cleveland, Ohio, May 2007. 7 February 1788. In my last, I showed that the judicial power of the United States under the first clause of the second section of Article 8 would be authorized to explain the Constitution not only according to its letter, but according to its spirit and intention. And having this power, they would strongly incline to give it such a construction as to extend the powers of the general government as much as possible, to the diminution, and finally, to the destruction of that of the respective states. I shall now proceed to show how this power will operate in its exercise to effect these purposes. In order to perceive the extent of its influence, I shall consider first, how it will tend to extend the legislative authority; second, in what manner it will increase the jurisdiction of the courts; and third, the way in which it will diminish and destroy both the legislative and judicial authority of the United States. First, let us inquire how the judicial power will effect an extension of the legislative authority. Perhaps the judicial power will not be able, by direct and positive decrees, ever to direct the legislature, because it is not easy to conceive how a question can be brought before them in a course of legal discussion in which they can give a decision declaring that the legislature have certain powers which they have not exercised, and which, in consequence of the determination of the judges, they will be bound to exercise. But it is easy to see that in their adjudications they may establish certain principles which, being received by the legislature, will enlarge the sphere of their power beyond all bounds. It is to be observed that the Supreme Court has the power, in the last resort, to determine all questions that may arise in the course of legal discussion on the meaning and construction of the Constitution. This power they will hold under the Constitution and independent of the legislature. The latter can no more deprive the former of this right than either of them or both of them together can take from the President, with the advice of the Senate, the power of making treaties or appointing ambassadors. In determining these questions, the court must and will assume certain principles from which they will reason, in forming their decisions. These principles, whatever they may be, when they become fixed by a course of decisions, will be adopted by the legislature and will be rule by which they will explain their own powers. This appears evident from this consideration, that if the legislature pass laws, which, in the judgment of the court, they are not authorized to do by the Constitution, the court will not take notice of them, for it will not be denied that the Constitution is the highest or supreme law, and the courts are vested with the supreme and uncontrollable power to determine in all cases that come before them what the Constitution means. They cannot, therefore, execute a law which in their judgment opposes the Constitution, unless we can suppose they can make a superior law give way to an inferior. The legislature, therefore, will not go over the limits by which the courts may adjudge they are confined, and there is little room to doubt but they will come up to those bounds as often as occasion and opportunity may offer, and they may judge it proper to do it. For as on the one hand they will not readily pass laws which they know the courts will not execute, so on the other, we may be sure, they will not scruple to pass such as they know they will give effect, as often as they may judge it proper. From these observations it appears that the judgment of the judicial on the Constitution will become the rule to guide the legislature in their construction of their powers. What the principles are which the courts will adopt it is impossible for us to say, but taking up the powers as I have explained them in my last number, which they will possess under this clause, it is not difficult to see that they may and probably will be very liberal ones. We have seen that they will be authorized to give the Constitution a construction according to its spirit and reason, and not to confine themselves to its letter. To discover the spirit of the Constitution, it is of first importance to attend to the principal ends and designs it has in view. These are expressed in the preamble. in the following words, that is, quote, "We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution," end quote, etc. If the end of the government is to be learned from these words, which are clearly designed to declare it, it is obvious that it has in view every object which is embraced by any government. The preservation of internal peace, the due administration of justice, and to provide for the defense of the community seem to include all the objects of government. But if they do not, they are certainly comprehended in the words, quote, "to provide for the general welfare," end quote. If it be further considered that this Constitution, if it is ratified, will not be a compact entered into by states in their corporate capacities, but an agreement of the people of the United States as one great body politic, no doubt can remain but that the great end of the Constitution, if it is to be collected from the preamble, in which its ends is declared, is to constitute a government, which is to extend to every case for which any government is instituted, whether external or internal. The courts, therefore, will establish this as a principle in expounding the Constitution, and will give every part of it such an explanation as will give latitude to every department under it to take cognizance of every matter, not only that affects the general national concerns of the Union, but also of such as relate to the administration of private justice, and to regulate the internal and local affairs of the different parts. Such a rule of exposition is not only consistent with the general spirit of the preamble, but it will stand confirmed by considering more minutely the different clauses of it. The first object declared to be in view is, quote, "to form a perfect union," end quote. It is to be observed, and it is not a union of the states or bodies corporate. Had this been the case, the existence of the state governments might have been secured. But it is a union of the people of the United States considered as one body, who are to ratify this Constitution if it is adopted. Now, to make a union of this kind perfect, it is necessary to abolish all inferior governments, and to give the general one complete legislative, executive, and judicial powers to every purpose. The courts, therefore, will establish it as a rule in explaining the Constitution to give it such construction as will best tend to perfect the Union, or take from the state governments every power of either making or executing laws. The second object is, quote, "to establish justice," end quote. This must include not only the idea of instituting the rule of justice, or of making laws which shall be the measure of rule of right, but also of providing for the application of this rule, or of administering justice under it. And under this, the courts will in their decisions extend the power of the government to all cases they possibly can, or otherwise they will be restricted in doing what appears to be the intent of the Constitution. They should do, to wit, pass laws and provide for the execution of them, for the general distribution of justice between man and man. Another end declared is, quote, "to ensure domestic tranquility," end quote. This comprehends a provision against all private breaches of the peace, as well as against all public commotions or general insurrections. And to attain the object of this clause fully, the government must exercise the power of passing laws on these subjects, as well as of appointing magistrates with authority to execute them. And the courts will adopt these ideas in their expositions. I might proceed to the other clause in the preamble, and it would appear by consideration of all of them separately, as it does in taking them together, that if the spirit of this system is to be known from its declared end and design in the preamble, its spirit is to subvert and abolish all powers of the state government, and to embrace every object to which any government extends. As it sets out in the preamble with this declared intention, so it proceeds in the different parts with the same idea. Any person who will peruse the 8th section with attention, in which most of the powers are enumerated, will perceive that they either expressly or by implication extend to almost everything about which any legislative power can be employed. But if this equitable mode of construction is applied to this part of the Constitution, Nothing can stand before it. This will certainly give the first clause in that article a construction which I confess I think the most natural and grammatical one, to authorize Congress to do anything which in their judgment will tend to provide for the general welfare. And this amounts to the same thing as general and unlimited power of legislation in all cases. To be continued. 14 February 1788. Continued from last Thursday's paper. This same manner of explaining the Constitution will fix a meaning, and a very important one too, to the 18th clause of the same section, which authorizes Congress to make laws which shall be proper and necessary for carrying into effect the foregoing powers, etc. A voluminous writer in favor of this system has taken great pains to convince the public that this clause means nothing, for that the same powers expressed in this are implied in other parts of the Constitution. Perhaps it is so, but still, this will undoubtedly be an excellent auxiliary to assist the courts to discover the spirit and reason of the Constitution, and when applied to any and every other clauses granting power, will operate powerfully in extracting the spirit from them. I might instance a number of clauses in the Constitution, which, if explained in an equitable manner, would extend the powers of the government to every case and reduce the state legislatures to nothing. But I should draw out my remarks to an undue length, and I presume enough has been said to show that the courts have sufficient ground in the exercise of this power to determine that the legislature have no bounds set to them by this Constitution, by any supposed right of the legislatures of the representative states may have to regulate any of their local concerns. I proceed second to inquire in what manner this power will increase the jurisdiction of the courts. I would here observe that your judicial power extends expressly to all civil cases that may arise, save such as between citizens of the same state, with this exception to those of that description, that your judicial of the United States have cognizance of cases between citizens of the same state claiming land under grants of different states. Nothing more therefore is necessary to give the courts of law under this Constitution complete jurisdiction of all civil causes, but to comprehend cases between citizens of the same state not included in the foregoing exception. I presume there will be no difficulty in accomplishing this. Nothing more is necessary than to set forth in the process that the party who brings the suit is a citizen of a different state from the one against whom the suit be brought, and there can be little doubt but that the court will take cognizance of the matter, and if they do, who is to restrain them? Indeed, I will freely confess that it is my decided opinion that the courts ought to take cognizance of such causes under the powers of the Constitution, for one of the great ends of the Constitution is, quote, to establish justice, end quote. This supposes that this cannot be done under the existing governments of the states, and there is certainly as good reason why individuals living in the same state should have justice as those who live in different states. Moreover, the Constitution expressly declares that, quote, the citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states. It will therefore be no fiction for a citizen of one state to set forth in a suit that he is a citizen of another, for he that is entitled to all the privileges and immunities of a country is a citizen of that country. And in truth, the citizen of one state will, under this Constitution, be a citizen of every state. But supposing that the party who alleges that he is a citizen of another state has recourse to fiction in bringing in a suit, it is well known that the courts have high authority to plead to justify them in suffering actions to be brought before them by such fictions. In my last number, I stated that the Court of Exchequer tried all cases in virtue of such a fiction. The Court of King's Bench in England extended their jurisdiction in the same way. Originally, this court held pleas in civil cases, only of trespass, and other injuries alleged to be committed vi et armis. They might likewise, says Blackstone, upon the division of the Aula Regia, have originally held pleas of any other civil action whatsoever, except in real actions which are now very seldom in use, provided the defendant was an officer of the court, or in the custody of the marshal or prison keeping of the court for breach of the peace, etc. In process of time, by a fiction, this court began to hold pleas of any personal action whatsoever, it being surmised that the defendant has been arrested for supposed trespass that, quote, he has never committed, and being thus in the custody of the marshal of the court, the plaintiff is at liberty to proceed against him for any other personal injury, which surmise of being in the marshal's custody the defendant is not at liberty to dispute, end quote. By a much less fiction, may the pleas of the courts of the United States extend to cases between citizens of the same state. I shall add no more on this head, but proceed briefly to remark in what way this power will diminish and destroy both the legislative and judicial authority of the states. It is obvious that these courts will have authority to decide upon the validity of the laws of any of the states in all cases where they come in question before them. Where the Constitution gives the general government exclusive jurisdiction, they will adjudge all laws made by the states in such cases void ab initio. Where the Constitution gives them concurrent jurisdiction, the laws of the United States must prevail because they are the supreme law. In such cases, therefore, the law of the state legislatures must be repealed, restricted, or so construed as to give full effect to the laws of the Union on the same subject. From these remarks it is easy to see that in proportion as the general government acquires power and jurisdiction by the liberal construction which the judges may give to the Constitution, will those of the states lose its rights until they become so trifling and unimportant as not to be worth having. I am much mistaken if this system will not operate to effect this with as much celerity as those who have the administration of it will think prudent to suffer it. The remaining objections to the judicial power shall be considered in a future paper. Brutus. End of Anti-Federalist Papers, Section 32, Brutus Letter 12.